Good morning, everyone. Welcome. Today we'll hear our oral arguments on the motion to dismiss filed by Bnsf Railway Company in this case, State of Montana versus Bnsf Railway Company, docket number 42124. In an effort to move things along, the board members will not be making opening remarks this morning, but I wanted to cover a few procedural matters before we begin. We asked each party to make a short statement of its argument, but counsel should be prepared to answer questions from the board at any time during your allotted time. I assure you that we have read all your pleadings and there's no reason to repeat every argument. We have the following time allotments for counsel. As the party filing the motion to dismiss, Bnsf has been allotted a total of 20 minutes with two counsel arguing jointly. Bnsf has requested 17 minutes on opening and is asked to reserve 3 minutes for rebuttal. If you wish to make a change to your reserved rebuttal time, please advise us when you begin your opening presentation. The State of Montana has been allotted a total of 20 minutes and has also requested to have two counsel argue jointly. Any party making a PowerPoint presentation or using similar hard copy aids using materials previously placed in the record should have provided those materials in hard copy 8.5 by 11 size to opposing counsel and the board. We will have any pages used today in such presentations bound into the transcript of the proceeding. Speakers, please note that the timing lights are in front of me. You will see a yellow light when you have 1 minute remaining, a red light when your time has expired. The yellow 1 minute light will be accompanied by a single chime, and the red light signifying that your time has expired will be accompanied by 2 chimes. Please keep to the time you have been allotted. When you see the red light and hear the double chime, please finish your thought and take a seat. In addition, just a reminder to everyone, please turn off your cell phones. We will now proceed. Counsel for Bnsf, please step up to the podium, introduce yourselves, and indicate if you wish to change any time for rebuttal, and then begin. Please.
Good morning. Thank you, Mr. Chairman, Vice Chairman, and Commissioner. My name is Richard Weicker from Bnsf Railway. With me and sharing this opening time is Sam Seif from Steptoe & Johnson. I will initially address the general nature of our proceeding and our Montana grain rates and our position, followed by Mr. Seif on several legal issues. Montana grain is a critical element of Bnsf's agricultural product business. We work closely with our shippers and customers, both for export and domestic purposes, to promote the most efficient practices in moving grain at all levels of the supply chain. This is a critical joint working effort from our standpoint, working with producers. We have normally dialogued and worked with these customers, including a recent reduction in 48 car rates, going back into the 1980s when BNSF first established a tiered grain rate structure that originally included the lowest rates on 52 car blocks, but eventually with the advent of larger, more efficient elevators, we introduced the shuttle train concept, which included currently 110 car shuttle trains, 48 car blocks, 26 car blocks, and rates on single cars. We believe that the right to determine the rate levels and the varying car load blocks is something which is granted to Bnsf Railway by statute. We set the rates and determine the breakpoints based on our perception of market demand, and with the goal of earning a sufficient return on our investment to maintain the viability of our long-term Montana grain operations as part of our overall network. The state of Montana's complaint in this case, challenging our decision to set rates applicable to movements in 48 car lots in lieu of 52 car lots, is at odds with that statutory rate-setting prerogative and is counterproductive. Mr. Seif will explain our position regarding several of the legal deficiencies in Montana's unreasonable practice claim, which is the basis of this motion to dismiss.
Is it your BNS view that it would be just as reasonable if you chose to charge single car rates for every car and offer no multi-car rates at all? Would that be your prerogative if you chose to do so?
Would be our prerogative to set the rates, this agency's prerogative, upon complaint to determine if those rates were reasonable, and in whatever the rates were that we published.
So you're saying there's no obligation to offer a 48-car rate or
no
a 26-car
obligation to offer
rate?
a 48-car rate.
Can you tell me, just following up on that, I understand your point that it's your prerogative to make these changes under the statute, but can you tell me your reasoning behind changing from 52 to 48? My understanding is that 52 was encouraged for quite a while at these various elevators, and people built their facilities for the 52, and then now they've been asked to use a 48 car rate. And can you tell me exactly why you made that change?
We changed as part of the evolution in our structure. We also changed 26s to 24. We have the 100-car shuttle rates as part of our view of what approached the market best, and there's no question about this, it also did fit in with the regulatory scheme that this board established with IRCs. We're not disputing that there is a difference between the way the board evaluates, just as we have the right to set a rate under 180% to make it presumptively reasonable and under the board's standards. That was part of this process a year and a half, 2 years ago when they were changed.
So the IRCs process itself, did that go into your thinking?
It was something cut there, I'm sorry. It was part of the thinking and the rationale in the way the structure was organized.
And then you also said it was a changing in your structure. I'm not quite following what you meant by that.
We also changed 26s to 24s.
Okay, so you changed it more to fit with the 48?
Yes.
Now,
I'm sorry.
So I'm still not quite hearing it. I just want to make sure I understand what you're saying is the 52 to 48 was driven by the IRCs, and you decided to change the structure from 48 to 24, 48 and 24. What's that?
26 to 24.
Right. So you've got these two changes that changes your whole structure, and then was it all driven by IRCs, or was there something else out there?
It was driven by an overall marketing decision. I can't say it was all driven by
And what was
IRCs.
the marketing basis for that?
The way our agricultural department thought they would best approach the market and what would be good offerings. But we're certainly not denying that the IRCs rationale was part of it. It was clearly a part of driving in terms of where these rates would be offered.
You can use the word profit maximization. I mean, that's basically what we're trying to do, is to maximize profits, which is what businesses are supposed to do.
And to protect
It's not a dirty word.
And to protect from undue regulatory challenges. There's nothing wrong with that. We could publish every rate on the system at 250%, 150%, 180%, wherever it was, under the rules that this board sets.
Sure.
And we believe that's something we're supposed to do to try to incent both movements in the free market.
So hypothetically, if the board decided to came out in a position in some kind of order saying that IRCs, even if you have a 48 car rate and then you throw in the 4 ones, if they all come from the same place, there's 52 cars that all come from the same elevator, 48 and 4 ones, would you still be doing that?
You would still, cars can be shipped that way, and this board clearly has jurisdiction over the reasonableness of the 48 car rate and every single car rate that is shipped on our railroad, as well as the 110 car shuttles and the 24 car units. That's quite clear. But from our standpoint, the board's jurisdiction is over the reasonableness of the rates we publish, not what decisions we make on what rates to publish, what packages, what volume discounts, how we structure those, we think is within our statutory prerogative under the statute.
I understand that. I'm just saying, would you still have this structure if the board decided that we're still going to treat 52 as 52? So if we make any adjustments in IRCs, they'd still be treated as 52, even if it's 48 and 4 ones.
I really don't know the answer to that, because if the board has an IRCs proceeding, which it's announced several times, and it changes things, such as the make-whole adjustment or the way IRCs is done in any respect, we would review in any given area what made sense to do. We might not change anything. We might change something. It would depend what came out of that. We take the rules that this agency promulgates as given in those areas. There is, to be very clear, we did nothing here to promote, unpromote this IRCs structure, this make-whole. I testified here myself last February or March, and we said we're quite open to the review of IRCs in many areas. How intermodal is done, how these kind of adjustments are done. We're not against that, but those are the rules that this agency has set, and therefore, if they changed, we could well adapt. In addition, just as there was a recent 48 car reduction, which had nothing to do with this proceeding, we could change things because of the market or the technology in elevators or the structure of elevators.
This is not a rate case, though. No one is challenged. My understanding is not challenging the rates in this case, but the switch from a 52 to a 48 plus 4, one would presume would probably have some change in the rates. Have the rates to Montana grain shippers gone up as a result of the change from the 48 to the 52 to the 48 plus 4?
To the best of my knowledge, rates on 48s went down.
Then the other,
I don't know the comparison, Vice Chairman, the precise one that you're doing. I can't do that in my head. I don't know.
Well, the other part of my question with this was that this is a case where it's not a rate case, it's a practice case, and they're arguing that Montana is arguing that the practice of encouraging all the elevator operators to build out to handle 52 and then turning around and saying, well, only going to give you a 48 car rate when you were offering a 52 car rate was an unfair practice. Now, given the circumstances of this case, can you understand where Montana might be coming from? They're encouraged to do one thing, they make the investment, and then the rug is pulled out from under them by not having the rate that was in place.
Vice Chairman, no shipper. It's interesting. We respect the state of Montana, but we don't have a complaint here against either the 48 or the singles or the 24s or the 110s. It's not clear who Montana represents other than in some broad political spectrum. Of course, it's the state of Montana, but there we don't have a single complaint from a shipper. We recently established our ADR process last year, so that's a matter of public record. Nobody's challenged any of these this rate change and so forth. Someone can always file a complaint if the charge of 48 plus 4 or the 48s or the 24s or 110 is too high, but we have the rate setting prerogative, and that's perfectly legitimate. I don't want to consume all of our time, but I'll be happy to turn over to Mr. Seifman.
If I could just follow up, I haven't had a chance to question you yet, and I'd like to, just for the benefit of our record here and for those who are observing this hearing who might not be full-time practitioners expert in the ways of IRCs and the make-whole adjustment, you've already said, and thank you for your forthrightness, that the IRCs process and how it might possibly be used in a future hypothetical rate case and the make-whole adjustment were all considerations that went into the, you said not the only consideration, but they were part of the package of considerations that went into this change from the 52 car block to the 48. Could you just walk us through what benefits would you believe would derive to a railroad under the make-whole adjustment by keeping the car blocks below 50?
Briefly, and I do not purport to be an expert in this and can stand corrected by anyone in the room, but the way IRCs works, the make-whole adjustment takes some general costs and puts them back in certain categories. There is a break point at 50 cars, I believe, in which general unallocated costs or general costs left in the waybill sample are added to lots under 50, including single car lots and under 50 cars, so that when you look at a chart of the way IRCs works, the cost levels and thereby the cost levels go up and the resulting revenue to cost ratios go down. I hope I did that right. And that is a breakpoint established by this board years ago. I don't know precisely what studies it's on, but with all due respect, this agency did that, not us.
So the general idea is if a railroad quotes a rate for less than 50 cars under our longstanding IRCs process, the railroad would get the benefit of being able to charge a higher rate than a block of over 50 cars.
It's not the benefit in the sense
if it were challenged in the future rate.
We believe that the market decides what we can charge and what moves the grain, and we want the grain to move. But the breakpoint results in a lower revenue to cost ratio under 50 cars because of the way IRCs allocates costs. I think I got it right that time. As opposed to the general allocation above 50 and 100 cars, which will have a different RBC ratio because of less more costs. Less costs.
Thank you.
All right. Sorry.
Help me understand what goes into change. I mean, it sounds to me, I've had the privilege of being able to visit Montana multiple times, meeting with growers and producers and railroad folks and all kinds of folks. And my understanding from those visits and from past proceeding we actually had on the grain market several years ago, is that this 52 car rate in black was, as the vice chairman pointed out, and the chairman as well, was a concept promoted pretty strongly by the BNSF Railroad, and it was somewhat controversial initially, less so perhaps in later years, but certainly substantial investments were made. So I've got to believe that the switch to 48 cars was not just a overnight decision by a summer intern law clerk at the railroad, that you gave some serious thought to this, and it took some resources to communicate out to all of your customers that there is now no such thing as a 52-car rate, but there was a 48-car rate. What I'm getting at is walk me through kind of the time and thought and investment that goes into making that kind of change, and I'd like to get into the discussion wondering what the benefits are, because it seems like the only real specific reason you've given is the very reason that Montana has cited in their brief, that this was an effort to quote-unquote game the IRC's costing model, which is probably not against the law. We have parties that game things all the time, and but it's interesting to me because we do have authority to look in, inquire into the business practices of the railroads, and we may be able to help you and help everyone as a result of this proceeding better understand how we would actually apply such a make-whole adjustment. But tell me, if you could, just respond to something like.
Well, briefly, the 52 to 48 car adjustment is more in the nature of a fine-tuning or an evolution of a process. The most controversial thing over the prior years, to my recollection, is really the whole promotion of shuttles, which our company has been in that territory pioneering on, pushing, encouraging, working with shippers to cite shuttle elevators. The most controversial is in some areas we've been in forums, both politically and regulatory, where the criticism is between the 110-car trains and the single-car trains, and what does this do to the country elevator? This is somewhere in between. This is an evolutionary fine-tuning that our marketing department did based on its own view. And gaming is an unfair pejorative term in the context of you can also view it as being respectful of the board's jurisdiction and trying to fine-tune to deal with the jurisdiction to make rates presumptively reasonable where we can, using the very rules the board has put forward. But this whole process has evolved over time and is regularly adjusted and by our marketing department to work with what fits best.
Mr. Weicker, is it fair to say, though, that the trend over many years on behalf of the BNSF and other railroads, is, especially in the agricultural sector, has been to encourage larger unit trains? 26s, 52s, 110s. In other words, doesn't this go kind of against the general grain, the general flow? Which, again, may not be a illegality or anything. I'm just curious.
It's within a structure because we've also gone all the way up to 110 now.
Right.
So, I mean, and we still have single cars and we still have the 24s and the 48s. There is a tuning within the structure, but we probably do promote bigger and bigger shuttle regional elevators that can handle large capacities.
Does this change from 52 to 48? Is this across the nation? Is this also true in the Dakotas and Washington State and other places where you carry grain from Minnesota, for example?
It was a general regional change, but I'm not sure I know the answer to that in terms of how far it went. I will be happy to address more, but I'll give Mr. Sipe an opportunity to address a couple of the legal issues if that's acceptable.
Sure. You have 10 seconds.
Good morning. I think I will abandon my planned remarks. I think the questions really put the issues in sharp focus. They're good questions, and Mr. Weicker answered them well. I want to answer them with particular reference to our legal theory here. And our legal theory is that where you have a statutory provision that says the carrier has the right to establish any rate with certain exceptions, you have to give that statutory provision very substantial weight. The exceptions are, unless the rate is unreasonably high. Everybody agrees that's not this case here right now. It may be lurking in the background somewhere, but it's not before you to decide right now. The other exception is unless the rate setting violates some other provision of this part. And Montana says, well, we've said it's unreasonable. Therefore, arguably, it violates another provision of this part. It can't be the case, when you think about this analytically, it can't be the case that an empty vessel concept like unreasonableness trumps a specific statutory provision. If you pour content into that empty vessel of unreasonableness, if you show how the establishment of this rate violates another provision or a policy of ICTA, then you've stated a claim for unreasonableness. But Montana hasn't done that here. They've simply used labels. They take the word unreasonable. They say that states a claim. Can't be the case. Suppose we change the color of the locomotives that we use to haul Montana grain. Montana comes roaring into the STB and says, outrageous. Those locomotives have been orange ever since BNSF merged. We want them back the way they used to be. Have they stated a claim for violation of ICTA? Does that violate a policy or a substantive provision of ICTA? No. And I think Commissioner Vice Chairman Mulvey's first question regarding the single car rates and whether or not a decision by BNSF to assess nothing but single car rates could be challenged, that points a finger at our legal issue. A challenge to nothing, a regime of nothing but single car rates, would be informed by the statutory common carrier obligation. There have been cases that have addressed the need to establish unit train rates, and they focus on the common carrier obligation, another provision of the statute. Here, there's no allegation that we've done anything that violates the statute.
Mr. Seif, if I could ask, couldn't your client, the BNSF, or Montana, conversely, have, if there was some question or concern about how this board would interpret the make-whole adjustment, let's say a farmer wants to move 52 or 62 or 79 cars, it's harvest time, that's the number that the farmer has the ability to load up, and they ask for a tariff rate for that number, isn't the railroad obligated to provide service and move that and charge a rate that relates to that movement, to whatever the movement size is?
The railroad is not obligated to establish any rate that the shipper asks for. The railroad's obligated to provide service on reasonable request.
Right, but the railroad can't say we don't move 77 cars ever. You know, only thing we're going to move for you is 48. Take it or leave it.
Well, the railroad can say you can tender cars in blocks of a 48 and a 26, and you know we can all do the math. Whatever you need to get to 77. There's a way of tendering traffic, right, and way billing it that it's going to get it to move.
But on this make-whole adjustment and this assertion that there was some strategic, I'll use a kinder word, some strategic thinking about possible future rate cases that drove the decision or partially drove the decision to go from a 52 car block to 48. If there was confusion or concern about or questions about how this board would handle such a scenario, aren't there other ways to bring that question to the board, such as a declaratory order petition, rather than have to go to the trouble of unreasonable practice?
There are other ways, Commissioner Nottingham, and we're not the ones who filed the case here. I mean, we think this case, frankly, I don't want to be harsh or insensitive, but we think this case is a waste of your time. There are a lot of important matters pending before this board. The issue of whether BNSF has the right to establish its own grain rate structure is simply not that big a deal. If any of these shippers, whom the state of Montana purports to be acting on behalf in some very loose, vague way, if any of these shippers has a problem, if any of them getting 48s now think the rates are too high, fine. File a complaint and tell the board exactly what your problem is. My problem is I'm paying a rate that's unreasonably high, and your costing rules are acting as an arbitrary barrier to my getting jurisdiction over those rates. I want you to change that right now, STB. That would be a direct way to pursue the relief that the state of Montana claims to be interested in here. Find a shipper who really has some skin in the game. We don't have any of those here. Find a shipper with a skin in the game and ask him to bring a complaint and ask the board for the relief they really want, which is some adjustment to IRCs. Don't go saying BNSF is gaming the regulatory system because we do exactly what the statute says we can do. I mean, suppose we, with all calculation, we go into a room, we shut the door, we pull the shades, we say, okay, guys, we're going to set a rate that yields an RVC of 178%, and that way the board won't have jurisdiction over our rates. Gaming, manipulation. No, it's exactly what the regulatory landscape provides, and this commission, this board, and its predecessor have never said that you can't do that. The final thing I'll say on this score is I commend for your close scrutiny the 1991 decision by the ICC in the abandonment case, Scobie-Opine. It's really quite close in many respects to what we have here, although obviously it's an abandonment case. But in effect, what the complaining Montana grain shippers were saying in that case when they opposed abandonment is BNSF is gaming the statutory scheme that allows them to abandon an unprofitable line. If they just maintained the rates they previously had in effect, the line would be profitable and would remain in service. And the ALJ bought their story. And the commissioners said, no. What they're asking you to do here is have this board second-guess BNSF's rate making, and we can't do that by statute.
Mr. Stipe, don't you agree that this board, though, does have the option or the ability to interpret how we're going to apply the so-called make-whole adjustment?
Absolutely.
And do we have to wait till a multi-year rulemaking proceeding is concluded to do that, or can we do that in a proceeding such as the one before us?
What I respectfully suggest is that you dismiss this ill-founded complaint, and if you want to advise Montana that if they can find a complaining shipper who's willing to come forward and challenge the make-whole adjustment in the context of saying my rate is unreasonably high, do that. That's fine.
BN is saying that the board should only be concerned with the published rate. But if a shipper tenders 52 cars instead of 48, wouldn't we as the board look at the total transportation rate, which could be the 48 cars plus the 4 singles, and wouldn't we plug that 52 car rate into IRCs phase 3, where we look at shipping characteristics, since this is a 52 car shipment? So we wouldn't look at it as a 48 plus 4, we would look at it as a 52, correct?
I think actually what you would look at is what's way-billed, and probably what would be way-billed would be a tender of 48 and 4 singles.
But in running it through IRCs,
that's how you'd get to IRCs in this case. You'd apply to the 48 cars way-billed as one lot. You'd apply whatever cost principles apply to a 48 car lot.
Well, the division in IRCs is 50 cars, so if it's tending 52, wouldn't you want to use the 50 car or larger rate as opposed to the 48 car smaller unit train rate, multiple car rate?
This question points to what a lot of people seem to perceive as a kind of arbitrary and inequitable break point in the IRCs cost allocation structure.
We really can't get into IRCs because it's an ongoing board study right now, so exactly how it's going to turn out depends upon a lot of things, but right now that's the way it is structured. So
I would just point out to you, Vice Chairman Mulvey, that one's perception of the equities of the way IRCs is currently structured depends on what side of the line you're standing on. Montana says that we have, quote, artificially increased the costs and evaded jurisdiction by establishing 48s. but it's equally plausible that BNSF could look at the 52-car costs under IRCS and say, this doesn't make sense that our costs for 52s should be very, very close to what they are for 110s. That doesn't make sense to us. 52s are not as efficient as 110s, and yet they're being treated substantially the same under IRCS if they're 52s. So we say, we've had enough of this. We've had enough of these consultants driving around Montana telling the shippers, boy, do you guys realize you're paying RVCs of 225%? Fine.
The 48's not close to, say, 5 or 6, the other break point. So 48 is pretty far from 5 or 6, as well as 52 from 110. I mean, it's obviously the issue of what the break points are, is a continuous function or what have you, but as I said, we're not going to...
Excuse me for interrupting. If you look at those costs, what you'll find out is that the costs, cost differential between the 52s and the 110s is far smaller than other cost differentials on the IRCS continuum. Thank you.
Thank you, Mr. Sipe. Why don't we let the state of Montana have a chance here. Mr. Cutler, you have 20 minutes.
Thank you, Mr. Chairman. I'm John Cutler, one of the attorneys for the state of Montana. My partner, Andy Goldstein, will address the grain marketing aspects of this issue, as well as the BNSF request to hold this case in abeyance. I think as a factual matter, the BNSF presentation has largely made our case. However, I have to take issue with Mr. Sipe's legal analysis. In fact, he ignores two of the most important provisions of the statute in this proceeding. If you look at page 1 of our complaint, you'll find that this case has been brought under section 10702 of the Act. That's the section of the statute that prohibits unreasonable railroad practices. Now, if you read the BNSF motion to dismiss, you won't find section 102 acknowledged at all. It's not there. Now, jumping ahead a little bit in my argument to a point made by Commissioner Nottingham about essentially a ripeness issue, and couldn't a shipper bring an action to contest this in the context of an actual captive elevator. Well, let me jump ahead to a second provision of the statute that's critical and that was ignored by Mr. Sipe and by the BNSF motion to dismiss, and that's section 11701B. They cite one sentence in that section that says that the board has the power to dismiss complaints that don't raise an issue worth investigating. Obviously, we allege smoke, and we're hearing that we were correct to do so. There was an effort to take advantage of the IRC situation. But back to 11701B. Section 11701B says two other things. One, you cannot dismiss a complaint for absence of direct damage to the complainant. Montana is a valid complainant here. It doesn't need a shipper. Second, 11701B authorizes governmental agencies to file a complaint. We chose to file a complaint rather than a motion for declaratory order precisely because we think this issue is very serious, and we wanted to put forward a case that the STB would have to address. A motion to dismiss, a motion for declaratory order discretionary. Action on a complaint must go forward unless you decide that the issue.
Let me ask you a question, Mr. Cutler,
yes.
Along those lines about, I understand, I get where you're going with the, the ripeness and the standing. Where I'm, and we got into a lot of discussion with Mr. Sipe and Mr. Riker about the IRCs and the adjustments and the make-whole adjustments, 52 versus 48. And what I'm wondering, based on what I'm reading in your complaint and in your filings, are we here today if hypothetically the board decides that if you bring 48 and 4 ones, we're going to treat it as 52 for the make-whole adjustment? Are we here today? Are you going to still bring that complaint if that's the board's decision on how it would treat IRC's make-whole adjustment?
Let me give my other reasons for, first, two things. One, that same section 11701 that I cited before absolutely gives Montana the right as parents patriae to bring a rate complaint if it so chooses. But let me complete my discussion of why that makes no sense, even aside from the 1170B prohibition against dismissal on that ground. If you brought a case like that, what you would essentially have is a two-phase rate case. Phase one would be, is it unreasonable for BNSF to impose a 48-car shipment size limit? If you got past the phase one, which is this case, and for which you don't need a shipper, only then would you address the rate case issues of the reasonableness of the rates freed from that restriction. But there's another factor here. When you decide that a railroad has engaged in an unreasonable practice, typically the STB doesn't direct the railroad to do exactly what it chooses. Rather, it says you must cease and desist from the unreasonable practice which we have found to exist here. That frees the railroad to respond to the board finding in a number of ways. We can't know today exactly how BNSF would remedy a board finding that its 48-car shipment size limitation is an unreasonable practice and must be ceased. Now that means that we can't know today. For one thing, take for example the shipper complaint case that Commissioner Nottingham raised. If a single shipper were brave enough to tackle this issue by himself, one of the things that BNSF might do is to fix the problem for that shipper. For example, by publishing a high 52-car rate applicable only to that elevator. This would leave the broader issue of the unreasonable practice in the gaming unresolved for all the other shippers in Montana, North Dakota, and so forth who face the same issue. The issue is presented on a broader basis here.
I see what your point is. I mean, I read the statute the same way you did. I'm not quibbling with you that way with respect to standing, but I really want to get to the crux of this case, which is whether or not, if it's 52, if it's 48, whatever the type of rate they set for a number of cars. But if we still treat it as 52, if it's 48 and 4-1s, that's really where I'm getting at. I just want to know if we're still here, if the board comes out and decides that the make-whole adjustment, we're going to treat it as 52 no matter what.
Mr. Chairman, that might have worked if that might have worked in 2008 because at that point BNSF had a 42 to 109 car rate. Now it's just a 48-car rate. There is no 52-car rate. There is no 48 to 109.
But you're not disputing that you can do the 48 and the 4-1s.
That would be a single-car rate and a 48-car rate case.
Okay, so they do the 48, they get 4-1s, and there's a make-whole adjustment issue that comes up, and the board decides we're going to stick with 52. You've got 52 cars there, it's 52. And I guess my question still remains, are we still here?
The problem there is there's no rate to bring a rate case against. There's no 52-car rate in the BNSF tariff. You could say we're going to...
This is a hypothetical, so if we just answer the hypothetical, whether or not, if there's 52 cars and we're going to treat it like 52 cars, if you're at an elevator and you send out 52 cars, no matter what, 48 and 4-1s, 26 and 26, and we decide that we're going to treat the make-whole adjustment as 52, does that satisfy what you've been arguing in your complaint?
I think so, because I think what you're saying, and let me flesh this out. We have alleged that, for example, a shipper with no transportation alternatives who in 2008 had a rate producing an RVC of 260, as a result of the 48-car shipment size limit, all of a sudden saw his rate RVC drop to 160. And of course, we're concerned not only about the inability to challenge the rate that we think is high, but the exposure to increase it. But if what you're telling me is that the board could apply IRCs in such a way as to recreate that 260 RVC for that captive shipper, then that's the relief that we're seeking. I mean, what we're concerned about is the inability of shippers to challenge rates they think are too high, and the exposure of shippers to further rate increases as a result of the gaming. And on the gaming point, let me say a couple of things. First,
Mr. Cutler, I'm sorry, but before we leave that train of thought and just follow up on the chairman's excellent line of questioning, this board, of course, I doubt will ever get to an outcome just to reach some specific RBC ratio. That's not what we do. We look at things like movements. What's the movement at issue? And what I would assume we would hear from Montana in a hypothetical rate case would be the movement at issue is 52 cars. We have farmers who need to move 52 cars. The railroads decided to bill that with a 48-car tariff plus 4 singles. Railroad would argue that it's a 48-car rate. State would argue that it's a 52-car movement and de facto 52-car rate, and we would have to address that as a board. And there, I think, there's an old military adage. Sometimes you need to know when to be willing to lose the battle in order to win the war. You might lose on a lot of your highfalutin legal arguments today, but you could very well end up winning on what I see as the major issue before us, which is whether or not this board would countenance the strategic gaming, whatever the word you want to use, interpretation of the make whole adjustment.
Well, I was in the military too, but I think one of the distinguishing features of this case, one of the ways that we differentiate this case from, for example, the Union Pacific decision on which BNSF relies. Union Pacific says that if the case only involves rate level, then you file a rate case. You don't file an unreasonable practice case. This case involves exactly the efficiency issues that you have raised. If it's a 52, if you can only ship, if you're set up to ship 52 cars, the efficient way for the elevator to operate, we can leave aside what's most efficient from BN's perspective. It isn't necessarily the same as the maximum efficiency of an elevator operation. You would order a 52-car block of cars, and you would load to capacity, and that's the way you would want to operate your elevator. Under the 48-car rule, we're assuming that BN would also supply a bunch of singles to go along with the 48s. We have no way of knowing that that's the case. There are car supply issues every harvest season, and this efficiency issue is part of the reason that we're challenging this, along with the impact on recourse to the STB. So I think that's a fair point, but I don't think it militates against going forward on the basis of Montana's complaint. I mean, some of the issues we're getting into here are issues that should be developed in the course of the proceeding, and not
just to try to boil this down a little bit. Do you agree that the railroad can do away with all unit car type concept pricing and just do single car pricing? Just say, for simplicity purposes, our rate per car is X, and if you got
I think you'd run
60 cars to move, it's 60 times X, and then you bring the rate case. If you had a rate case, you would say, I tried to move 60 cars at 60 times X, and I think the rate's unreasonable.
You would run into the same problem we've asserted here. It's a different version of that problem, and in fact, the problem doesn't go away if you change ERCs. If the breakpoint shifts, there's still got the question of whether it's an unreasonable practice for railroads to use shipment size limits to force you from the right side of the breakpoint to the wrong side of the breakpoint.
Just to follow up on one thing you said, and that was a cost supply issue. Someone suggested that part of the argument here, or part of the problem here, is that there is a cost supply issue, that BN is no problem in terms of supplying 48 cars to these shippers, but the extra cars, the extra 4 or 5 cars, et cetera, there may be a cost supply shortage. Is that your understanding, that part of the problem may be a cost supply issue here?
Vice Chairman Mulvey, we wondered if we would get that argument. We have not. However, that's the kind of thing that proceeding is for.
One more question. You here representing the state of Montana, but as BN points out, Montana is not itself a shipper. And you're representing shippers, but we don't see a lot of the grain elevators throughout the state here with you supporting the state in its effort. And you mentioned if they didn't have the courage, they might not have the courage to do so, or Do you want to elaborate on that? Are we hearing this story again about retaliation or what have you?
A couple of things. First, even major corporations don't take on major railroads without a lot of careful thinking and a lot of concern. You know the issue of utility coal shippers who face enormous rate increases upon expiration of their contracts. It's not the kind of thing that, and the same with major corporations in the agribusiness area. Here we're talking about smaller elevators, not shuttle elevators. Moreover, you have a letter attached to our reply to BNSF's motion to dismiss from the Montana Farmers Union.
Mm-hmm.
We do have support from, this is not something that was just made up in the AG's department or the Montana Department of Transportation. This reflects a concern about the vulnerability of some of the weaker elevators, which are nevertheless important for Montana farmers because they're nearby. They cover crops other than wheat, barley, and so forth. They're sources of fertilizer and marketing and so forth. There are about 4 times as many of these mid-sized elevators in Montana as there are of the shuttle elevators, and the state needs them. And we're concerned about the ability of those elevators to survive if recourse to the STB is taken away because of the shipment size limit.
Thank you.
Mr. Goldstein? Thank you, Mr. Cutler.
Thank you, Mr. Chairman, Mr. Vice Chairman, and Commissioner. I really hope to cover 2 issues, as John said a moment ago. And the first is BN's purpose for making the 52-car adjustment to 48 cars, which you've been interested in. And the second is the question of whether this proceeding should be held in abeyance indefinitely, as BN requests, pending the outcome of a rulemaking that's not yet been instituted. But before I get to that, I want to just correct one misstatement I think I heard Mr. Weicker make, which was that since the 48 cars were instituted, the rates have come down. According to our calculations, the rates have been increased 3 times, and only very recently was there a small reduction, so that the net effect is that there has been a $376 per car increase in the 48-car rates since they were placed beyond the board's jurisdiction through application of the make-whole adjustment. Now, BN really hasn't made any claim that it switched to the 48 cars because of marketing efficiencies. They said at one point that 52 cars were their most efficient mode. Now they say shuttles are, and indeed that's probably true. But of course where that leaves us is that 48 cars are not. So we cannot find an efficiency motive in what they've done. Our research also discloses that the 48 cars did not come into existence in response to any discernible market demand. We believe the evidence will show that given a choice between 48 and 52 car shipments, the marketplace chose 52 cars. And it wasn't until after BN eliminated 52 cars that any significant use was made of 48 cars, even during that 3 and 4 month period when they had both types of rates in place. The result of this, of course, is the variable costs associated with the 48 car shipments are substantially higher than those with the 50 car or larger shipments. And these variable cost differences can exceed $1,000 per car, in many cases lowering the RVC ratios below 180%. We take the position, of course, that the use of the make-whole adjustment in that manner is an unreasonable practice. Now, BN acknowledges that the crux of the complaint is misuse of the make-whole adjustment. The board's indicated its intention to commence an IRCS examination, but no proceeding has been initiated. And as far as we can tell, Congress has not provided the funding the board needs. At best, that proceeding will take 2 years if things go well, but they never do. And so 2 years is an unrealistically short decisional expectation. If the proceeding takes longer than 2 years, it could be 2013 or later before this issue could be revived by Montana. During that time, critical documents now available through discovery could be misplaced, or BNSF personnel whose depositions could be taken now might leave or retire, making it much more difficult to present evidence behind BNSF's decision to impose its 48-car limit. And more importantly, BNSF would be free to impose several years' worth of rate increases beyond the board's jurisdiction. In prior cases, the board has refused to indefinite abeyance requests. In Ex parte 589 in 2003, the board refused to hold a cost of capital calculation for a given year in abeyance, pending the outcome of a general review of cost of capital. And in Ex parte 477, the board was asked to hold a rulemaking in abeyance until final adoption of the IRC system, but it refused, saying this: despite the Commission's intent to issue shortly a notice of proposed rulemaking on the implementation of IRCs and plans to issue final rules in the spring, the completion of the proceeding is not a certainty. There could be delays in the process, or the rulemaking process could introduce new issues or indicate new problems. Delaying this rulemaking in anticipation of IRCs is speculative. And even if the board, and this is perhaps the most important of all, even if the board were to complete an IRCs rulemaking and maintain the make-whole adjustment, the central issue raised in this complaint will not disappear. Regardless of how the make-whole adjustment operates, the board will have to decide whether railroads can impose shipment size limits designed only or primarily to increase IRCs' variable costs, thereby deregulating rates on shippers with no other transportation options. Holding this case in abeyance pending an IRCs rulemaking wrapped in uncertainty would have adverse procedural and substantive effects and should not be pursued by the board. I'd like to then just address one last subject, which has to do with some of the questions being asked about 48 cars plus 4. And I believe that BN's answer was how you would treat those would depend on the waybill. Now, I think we all realize that the reason that railroads publish 48 car shipments, or 52, or 110, is because they want those 48 cars to stay together as a unit. They want to be able to have them loaded at one time, at one place, and delivered at one time and one place. If you try to add single cars onto that, you have no telling when you're going to get them. You order single cars and you get them at the railroad's preference. And so what happens now is that instead of having to call a crew out to load a 48 car shipment, you now have to call one out, or a 52 car. You now have to call one out to load a 48 car, and then on 4 other occasions, perhaps, to load single cars. It's a horribly inefficient alternative, and the presumption should not be made that just because 4 and 48 add up to 52, you will get 52 cars in a shipment at one time from BN. And thank you.
Thank you, Mr. Goldstein. Mr. Weicker, you have, and I apologize for, I think I mispronounced your name before. You have 3 minutes on rebuttal.
We will be brief and just respond to a couple of the points that were made. First, in response to Mr. Goldstein's assertion, we have neither acknowledged nor, in fact, in any way misused IRCs. It's this agency's IRCs. Just like the many rules that are promulgated, we follow those rules. If there is a problem here, there is a remedy, but it's not an unreasonable practice case. There's a remedy to review IRCs as application in an individual rate case, and I'm not going to go into this. I mean, you could argue endlessly, but it should happen in that rate case, whether you do how you count them and what you do, but that's this board's jurisdiction. We don't deny that jurisdiction. There's no shipment cap we're talking about here, no car supply issue. There's a simple, if they're unhappy with the rate, bring a rate case and you can address it or examine IRCs. We have the initiative by statute to decide what kind of discount lots we offer. That's what this is all about, is discount lots and whether there's enough of a discount or a rate. We could offer, a manufacturer can offer a 5 package of paper towels or a 6 or a 3. You happen to have the jurisdiction to decide if the price for those discount lots are appropriate and reasonable under this statute. But with all due respect, you can't tell us to offer a 4-pack of paper towels instead of the 5 or a 7. That's up to us. We aren't deciding or limiting anybody's ability to ship on our railroad as much or as little as they want and what they bill it under, and then you have the jurisdiction if that rate is unreasonable. They keep talking about rate levels. Then it is a rate issue. It's not a practice issue. That's the difference here in what we think is the basic statutory right. We have to set the rate, and they have the right to challenge it, and we're following the rules on IRCs. We didn't make them. They weren't made for this at all. They came from this agency. Thank you.
Thank you, Mr. Weicker.
Mr. Weicker, if I just to
Yes, sir.
make sure I understand your last point there, you believe that then this agency, to add on the natural following thought, at least that occurs to me, that your client is just behaving reasonably in accordance with this agency's decisions and rulemakings in our IRCs process and the make-whole adjustment. Therefore, wouldn't it naturally lead to the conclusion that this agency then, if there is a problem, should clarify that issue or correct the situation?
Yes, sir. It is the agency's jurisdiction to review the IRCs cost proceeding. If the cliffs aren't right, the angles aren't right, I personally think the proper place to do that is an IRCs proceeding. I would not deny in any way the board's jurisdiction if a complaint were brought in these iterations we've been talking about the last half hour of 7 plus 3 plus 42 plus 24 and how do you count it? I personally think that you would follow your rules and you'd count against the rate, but you've got the jurisdiction to do it in a case. I don't think that's the right place to do it because it permeates. There are many other parties besides the state of Montana as appeared before you in the IRCs proceeding earlier this year who have an interest in these adjustments. And you start fiddling with this stuff, whether it's on intermodal or the make-whole adjustment or whatever it is, the regression analysis, that is a system which has been established over many years. We criticized aspects of it from the standpoint of we'd like to think positive criticism, it should be improved and updated. But that's a different issue than fiddling with it in one case. Would I deny you have the jurisdiction to do that? Of course not.
Thank you.
Thank you very much, Mr. Weicker. Thank you, both parties, for excellent arguments. We'll take the matter under advisement, and the hearing of the board is now adjourned. Thanks.